Hello friends, in the series on the income tax cases, today we will discuss the case of Maharishi Institute of Creative Intelligence versus Commissioner of Income Tax Exemptions. This case has been reported in 454 ITR at page number 533. The matter has been decided by Honorable Supreme Court and the date of the judgment is 18th April 2023. This case is beneficial for all those trust institutions, societies who are working for the charitable purpose and who have applied for the registration under section 12AA before 1997, but they have not been given the certificate of registration, or anyhow they do not have the certificate of registration or the registration number, but from a long period of time the department is giving them the benefit of section 11 on the basis of application for registration under section 12AA. In this case, four sections will be discussed. Section 11, which talks about income from property held for charitable or religious purposes. Section 12, which says that income of trust on institutions from contributions. And section 12 gives the conditions for the applicability of section 11 and 12, and section 12AA, which talks about the procedure of registration. In the present case, the assessee applied for registration in 1987. Since 1987 up to the assessment year 2007-8, the assessee was claiming the benefit of section 11 on the basis of the application of registration under section 12AA, and the department was giving this benefit. As all we know, in 1997 an amendment was brought in section 12A, which says that only the application for registration is not sufficient. The assessee should be granted the registration for claiming the benefit under section 11. For assessment year 10-11, the scrutiny proceedings were going on. The assessing officer allowed the benefit of section 11 on the basis of application of registration of assessee in 1987, and since the assessee was claiming the benefit of exemption under section 11 since 1987 up to assessment year 7-8. But the CIT suo motu revised the order under section 263 and said that the order passed by the learned assessing officer is erroneous and prejudicial to the interest to the revenue, because the assessee is not able to produce the registration number or the registration certificate as per the requirement of the amendment in 1997 in section 12A. The assessee filed the appeal against the order of the CIT before the ITAT, and ITAT allowed the appeal of the assessee and said that in the present case the law which was applicable in 1987 on which the assessee has applied for registration will be applicable, and not the law which has been amended in 1997. The ITAT also said that it is not the case of the department, that the department has objected from 1997 up to 2007-8 that why the assessee is claiming this exemption, because in 1997 there was an amendment, and from 97 also up to the assessment year 7-8 the assessee was given the exemption under section 11. So the ITAT allowed the benefit of section 11 to the assessee. The department moved to the High Court, and High Court reversed the order of the ITAT. The assessee filed review petition in the High Court against the order of the High Court, which was also dismissed. So the assessee do not have any option other than going to the Supreme Court. The Supreme Court reversed the order of the High Court and upheld the order of the assessing officer and the ITAT by saying that in the present case, the law applicable in 1987 will be applicable when the assessee applied for registration and the department has not objected the benefit of section 11 to the assessee from the date of the amendment, that is 1997 up to the assessment year 7-8. So in the assessment year 10-11 also, the assessee cannot be denied the benefit of exemption. Friends, this case is very important for all those institutions who are struggling with the same issue, that in the previous years they have been given the benefit of section 11, but due to this technical glitch that they do not have in their records the registration number or the registration certificate. So because this case has been decided by Supreme Court, now it is a law of land. At the end of this video, once again I am repeating the name of the case. The name of the case is MAHARISHI Institute of Creative Intelligence versus Commissioner of Income Tax Exemptions, and this case has been reported in 454 ITR at page number 533. The matter has been decided by Supreme Court and the date of the judgment is 18th April 2023. Thank you, friends.